Hello, I'm attorney Jeff Morrell, and this is the first in my series of short informative videos entitled Basic Rights of the Criminally Accused. The right to remain silent is grounded in the Fifth Amendment of the United States Constitution and Article 1, Section 8 of the Wisconsin Constitution. The Wisconsin Constitution, by the way, is the oldest constitution outside of New England. The right to remain silent extends even to those persons who are not formally charged with any crime. If you even suspect that you're under investigation by law enforcement or any governmental agency for criminal wrongdoing, you may invoke your right to remain silent. You may do so even at informal meetings with prosecutors, such as at a pre-charging conference, or any other type of governmental investigator. This right absolutely protects you even if you don't know that you're being charged criminally, or even if you just think it's possible that you might be charged. You can invoke that right. A lot of people don't know that. Unfortunately, I know some attorneys who don't know that either. This invocation of one's Fifth Amendment right to remain silent absolutely 100% protects a person in a formal criminal matter. It can even be invoked in a civil matter. For example, if someone's suing you and you're questioned about activities that you think might rise to the level of criminal wrongdoing, you can invoke your Fifth Amendment right to remain silent. A real good example of when we use that in a civil matter here in Wisconsin is when a person is charged for an OWI, driving while intoxicated, first offense. In this state, and this is the only state where this is true, a first OWI is simply a civil ticket. You are not looking at any deprivation of liberty, no jail time for that in the state of Wisconsin. So if you decide to challenge a first OWI in municipal court and you go to trial and you think that you might be the subject of some criminal investigation from your testimony, you may invoke that right. However, in a civil matter, it does not 100% protect you. In a civil matter, your silence may be used against you, unlike in a criminal matter. I had a trial many years ago when Supreme Court Justice Louis Butler was a Milwaukee Municipal Court judge. It was a first-time DUI for my client. There were some other allegations involved that we thought might rise to criminal conduct. She invoked her Fifth Amendment right to remain silent, and then Judge Butler completely held it against her. The law says that the judge and a jury in a civil matter may consider your silence as an admission of guilt. So, your right to remain silent basically lasts forever. It never expires. Unless, of course, you voluntarily, knowingly, and intelligently agree to enter a plea of guilty or no contest in a plea arrangement. If you negotiate a plea bargain with the prosecutor, you or your attorney, and in exchange for your guilty plea, the prosecutor agrees to recommend something specific at sentencing, then you are opening your mouth, you're saying you're guilty, and you are, by that very act, making incriminating statements against yourself. That then waives forever your right to remain silent, and you're then obligated to speak in detail about the crimes that you're accused of. So what happens if you're arrested and the police are interrogating you and they trick you into making statements against yourself? Well, you have a very strong defense in that situation. Everyone in this country does, not just in the state of Wisconsin. This is federal law. If you're in police custody, they're interrogating you, and the police have techniques that they formally study where they can turn a yes into a no and your no into a yes. Then what you do is say, I want a lawyer. Be completely unambiguous about it. What does unambiguous mean? It means be very clear about your desire to have the assistance of counsel. Don't beat around the bush. Don't ask weak, ineffective questions of the interrogator such as, "Oh, don't you think I need a lawyer?" or "I think I should talk to a lawyer at this point." Don't. What you say is, "I want a lawyer," period. According to federal law, all interrogation must then cease. Any statements you make after demanding the assistance of counsel are then to be suppressed. Most good cops know this. Unfortunately, there are some out there who don't. So that's why we have a suppression remedy to suppress statements that are taken in violation of one's right to counsel. If you think you're a suspect in any federal or state criminal investigation, or if you're already charged, call me immediately. I give free consultations, and I have payment plans. So talk to me. That's a lot of what I'm here for. Doesn't cost you anything but your time to pick up the phone to ask me what all your options are. Attorney Jeff Morrell. I'm based in Milwaukee, Wisconsin. Phone number is area code 414-224-0668.